Welcome to the Superior Court of California. This video will provide you with information about the small claims court process. It will also provide you with information about mediation, which may help you to resolve your small claims dispute without a trial. Small claims courts deal with many types of cases involving $7,500 or less. For example, you can have a small claims case about damage to property, security deposits, or disputes about payment for services provided. Small claims court is less formal, less time-consuming, and less expensive than regular civil court. Lawyers are not allowed to represent the parties in small claims court, so the people in the case talk to the judge directly. Each side explains their case and brings proof and witnesses to back it up. Then the judge applies the law to the facts and makes a decision based on the law. This video will give you a brief overview of the process of filing a small claims case and going to court. It will also give you information on the Small Claims Legal Advisor, a service in every county to help you with your small claims case. Once you understand what is involved in going to small claims court, you will learn about mediation, which is an alternative to having a judge decide your case. Mediation can often be a very good choice for people who have a small claims dispute, and this video will explain why mediation may be right for you. Let's first talk about what a small claims case is like. Once you decide you're ready to file a case, you need to fill out court forms. If you are the plaintiff, you need to fill out a claim form. If you are the defendant and want the plaintiff to give you money or property, you need to fill out a counterclaim form. After you fill out your forms, you must file them with the clerk's office and pay a filing fee. If you cannot afford the fee, you can apply to the court for a fee waiver. Before your court hearing, the law requires that you let the other side know that you're suing them in the proper legal way. This is called service. There are different ways to serve the other side, and the rules are very strict. If you don't serve the other side the way the law requires, the judge cannot hear your case, and your hearing will either be postponed or canceled. Because service is complicated and must be done correctly, we urge you to talk to your small claims advisor to make sure you do it properly from the beginning. Once you serve your claim, you need to prepare for your court hearing. Because hearings are only 5 to 10 minutes, you must be organized and able to present your information quickly without getting sidetracked. Remember that the hearing is your only chance to explain your side of the case to the judge. To prepare for your hearing, it is important to understand the law in your case. Get your evidence ready, items such as photos, bills, receipts, and contracts. Talk to witnesses and make sure they will come to your hearing. Go to the courthouse and watch a small claims hearing so you'll know what to expect. During the hearing, the judge listens to both sides, reviews the evidence, and asks questions. The judge will base his or her decision on the law, which limits what he or she can order. The judge may make a decision at your hearing or mail it to you later. This can take up to a month and sometimes even longer. If you are not completely comfortable speaking and understanding English, bring a qualified interpreter. The court will probably not be able to provide one for you, and you want to make sure you understand everything that is said and that you can be understood. The defendant can file an appeal within 30 days after the judge's decision is handed out or mailed. If the defendant does not file a valid appeal within that time, the judge's decision becomes final. The plaintiff cannot appeal the decision on his or her own claim, but can appeal the decision on a claim filed by the defendant. If there is an appeal filed, you have to present your case again. This time, you are allowed to bring a lawyer to represent you if you want. If you are the plaintiff and you won the case, the defendant might not pay you voluntarily. The court cannot collect the money for you, so the burden is on you to enforce the judgment. Efforts to collect your judgment can take time and money and can be frustrating. If you lose the case, you may have to pay the other side's costs on top of what you owe. Also, the court judgment against you could hurt your credit. Mediation is a great alternative for resolving your small claims dispute. Mediation is where you and the other party meet with a neutral person, called a mediator, who is specially trained to help people resolve their disputes without needing to go in front of a judge. In mediation, everyone works together to find a solution instead of having the judge make a decision. The mediator will not force you to reach an agreement. Whether you decide to resolve your dispute and how you resolve it is up to you. And if you can't settle, you can still have a judge decide your case. There's nothing to lose by trying mediation, and there is much to gain. There are a lot of reasons why it is a good idea to mediate your small claims dispute, whether you are the plaintiff or the defendant. Many people are more satisfied with the process and results of mediation than with a court hearing. You should consider mediating your case because mediation sessions are conducted at a slower pace. In mediation, you have more time to discuss your situation and talk about the issues. During a court hearing, you may only have 5 or 10 minutes to present your case. Conversations in mediation are private. What you say in mediation is confidential and normally cannot be repeated in court later. Court hearings are open to the public, and everything you say to the judge will be heard by everyone who is sitting in the courtroom. Issues not relevant to the court can be discussed in mediation. In mediation, you can talk about issues that a judge would not be able to consider under the law, but are very important to you and how you feel about the dispute. If you go in front of a judge, the judge has to apply the law to the facts of the case and take into account only those facts that the law considers relevant. Settlements in mediation are not limited to money. A judge usually has to decide if one party owes another party money. In mediation, the parties can reach other types of agreements, like giving one side a chance to fix the problem, return property, or apologize. In mediation, you have more room to create an agreement that suits you and your particular situation. There is no deadline for settling a case in mediation. Different types of cases have different deadlines by which they must be filed. If you file a claim in court after the deadline for your type of case has passed, the judge will have to apply the law and you will lose your case. But you can still resolve your case in mediation, since you, the other side, and the mediator have more flexibility than the judge and can make an agreement beyond what the law requires. Mediation can help maintain relationships between the parties who have the dispute. Mediation can be particularly beneficial in disputes between neighbors and family members. It allows the parties to work together to reach an agreement instead of a judge making a decision for them. This can help avoid or resolve future disagreements. Mediated agreements are often more likely to be followed. When the judge makes a decision, at least one side usually doesn't like the order, and often neither side is happy. In mediation, both sides usually agree on the outcome, so everyone is likely to follow it. Collecting your money or property may be easier. If you reach an agreement through mediation, you may not need more court hearings. The other side is more likely to pay you because they were part of reaching that agreement. Settlements reached in mediation may not affect your credit. If you lose in court, the court will enter a judgment against you, which may show on your credit report and could hurt your credit. In mediation, you may be able to reach an agreement that does not affect your credit. You can go to mediation anytime. If you're having difficulty resolving a dispute with a person or business, you can suggest mediation to the other party. When doing so, it may help to give the other party information about mediation. Consider giving them a copy of this video or other written information. Also, you may consider asking the other person to suggest a mediator to help resolve the dispute. If you are sending or responding to a demand for payment or for a problem to be fixed, before filing a claim with the court, consider asking the other party to mediate the dispute. Some mediators will even call the other party for you, explain mediation to them, and encourage them to mediate your dispute. Remember, you can ask the other side to mediate your dispute before or after a small claims case is filed. Preparing for mediation is a lot like preparing to go to a court hearing. It is important to identify and organize the facts that are relevant to your dispute. And you should make sure you know about the facts that support the other side, not just those that support you. It is also important to understand the law that applies to your dispute. If you are going to mediation before or instead of a hearing, there are some other things you should do to prepare. Think realistically about how the judge will decide the case if you don't settle in mediation. Consider whether you or the other party is angry or has hurt feelings, and why. Think about what you and the other party would really like to accomplish. Consider if something besides or in addition to money might help satisfy you or the other party. Come up with a list of alternatives that both parties might agree on to avoid going to a hearing, or the possibility of losing, or not collecting if you win. Remember that, like at a hearing, the court will probably not be able to provide you with an interpreter. So if you do not speak or understand English well, you should bring your own interpreter to your mediation. At mediation, be sure to present your side of the dispute clearly, and to listen carefully to the other party's point of view. Make suggestions for how to settle the dispute, but also listen openly to other ideas. Remember that mediation is about give and take. Everyone has their own point of view. Although you may feel like you're 100% right, you may learn things that help you better understand the problem and resolve the dispute. Many counties have nonprofit dispute resolution programs that provide free or low-cost mediation before or after a claim is filed. Many small claims courts offer free or low-cost mediation either before the hearing or on the day of the hearing. Private mediators are available in many communities, and they often advertise in the Yellow Pages, newspapers, or on the Internet. Private mediators' backgrounds and fees vary considerably, so be sure to ask. To find a program near you, ask your court for a list of mediation programs in your area. Free assistance is available to help you with your small claims case. All courts in California have a small claims advisor or self-help center. Advisors can cover the information provided in this video in greater detail and can help you explore whether mediation may be a good option for you. Advisors can also help you to find a mediator. You can find out about the small claims advisory services in your county by asking your local court or law library or by visiting www.courts.ca.gov/self-help. On this website, you can get more detailed information about small claims cases. You can get help writing a letter to the person who owes you money, receive assistance filling out the small claims forms, and find links and information to your local court. You can find out about the small claims advisory services in any county by visiting www.courts.ca.gov/self-help. You can find the forms you need to fill out and file with the court at www.courts.ca.gov/forms. We hope you found this video helpful, but this information may change, so be sure to research the current laws and court programs for your case. Remember, there are a lot of resources available to help you. Thank you for watching.